1. Order. Good morning, everyone. Welcome to Northern Ireland Affairs Committee, to members and to our guests. We're looking at the legacy of the Troubles this morning. I'd like to ask our guests this morning to introduce themselves, if you may.
I'm Peter Sheridan, so I'm the Commissioner for Investigations with the Commission.
Declan Morgan, I'm the Chief Commissioner.
Louise, Hunter, Chief Executive and Commissioner.
And I'm Stephen Bramley, General Counsel.
Good morning. So Declan.
I just wanted, Chair, literally for a few seconds to set out 4 propositions. The first is that our focus is on finding a mechanism to ensure that we achieve the unvarnished truth for victims and survivors. Secondly, the High Court and the Court of Appeal in Northern Ireland have found that we are capable of doing this in an Article 2 compliant way in most, but not all cases. Thirdly, the litigation that has occurred in Northern Ireland has been very hard on families. And with hindsight, I just wonder whether we could all, as lawyers, have done better in dealing with it. And fourthly, this is a reset moment. We need to make the changes to this imperfect legislation that will support the 2 governments and help us in the project of finding the truth.
Thank you, Sir Declan. We'll begin our questions now. So I'll take the first question, Sir Declan, and this is to yourself in the first instance. So we have heard a range of evidence suggest that there is a lack of confidence in ICRIR, in part because of the perception, at least, that the purpose of the Legacy Act was to stop investigations into veterans. Can I ask how the Commission can address those issues and gain and retain the trust of all communities?
I think part of the answer is that it's very difficult in this environment to obtain the confidence of absolutely everybody in legacy projects. We understand that we've heard the people who are disappointed about the fact that we have committed to using this legacy mechanism, and I understand their hurt. These were people who were very shabbily treated by the legislation that was brought in, which ended any prospect of both inquests and civil proceedings. But from my point of view anyway, I looked at the legislation not to see what it did that perhaps was wrong, but to look and see what it could do that would help. And I think we have demonstrated that this legislation had the ability to provide answers for people. We have over 160 people who've now come to the Commission. We have now over 60 investigations which are ongoing in relation to various cases. Those would not have happened if we had not looked at the opportunities that this legislation has provided, and we can do all of those things in an Article 2 compliant way and in a way which will eventually secure the unvarnished truth. By the end of this year, we will have over 100 investigations in relation to probably more than 150 deaths ongoing, and by the time of the legislation, we would expect that that number would have significantly increased, as will the number of people that we've been able to help. So the choice was whether to help those people who were anxious to have an answer to what they wanted, or to stand back and say this legislation is not perfect. Well, I don't make any apology for the fact that I decided that I wanted to help people. And I think when people understand that and see what has happened and analyse it, I just wonder whether the approach to the work of the Commission will be treated in such a negative light, particularly when the 2 governments reach agreement on what they want to do.
Thank you, Sir Declan. If I can turn to Peter, you told the Assembly in February that you were willing to sit down with critics of the Commission to explain that you're not undertaking merely desktop reviews. Have you done that? And if so, what's the Commission's engagement strategy with its detractors, especially including families?
So that offer still open to anybody who wants to come to us, because unconscious people talked about it's a light touch review or desktop review. Let me assure this committee that it is absolutely not. Once a family who has come to us and have decided that they want the commission to continue, then the first thing I do is put it into what's called scoping, or what would be known in the police as a cold case review. So that will look at a structured and objective review, free from previous biases of investigation. It will look for new evidence, verify old evidence and identify investigative failures in it, re-examine forensics, and that's going to be the key to us, because witness evidence from the past is difficult, but new forensic opportunities, and I already see it in some of the cases of new forensic opportunities that have already we have already come across in some of the investigations. So we're examining that for the latest trace evidence that you can use, looking at continuity of evidence in old cases, conduct fresh searches on databases, and use advancement in digital forensics. So it is absolutely not a light touch review. It is, I am duty bound under legislation to look into all of the circumstances of the case. That's what we're doing. And just to give you an example, because sometimes we talk in the round about all of this. So Sir Declan said of over 60 live investigations. So that includes at the minute the death of 5 people from the bombing at the Horse and Groom public house in the 5th of October 1974, commonly called the Guildford pub bombings. It includes the death of Alexander Miller at Ardoyne Bus Centre in Belfast in 1975, when 2 gunmen entered the premises, asked for him by name and shot him in the head, chest and groin. It includes the death of Seamus Bradley, a 19-year-old IRA man who was shot dead by the army in Derry on Motorman. It includes the death of James and Ellen Seffern in Belfast in June 1990, shot dead by the IRA. The death of Rory O'Kelly, shot dead by the IRA in Coal Island in March 1977. The death of William Marchant on the Shankle Road in Belfast in 1987, when a car pulled up alongside him. 2 gunmen opened fire, and the IRA claimed responsibility, saying he was a leading member of the UVF. It includes the death of Judge Rory Conaghan by the IRA at his home in front of his family at 08:30 one morning at his house. It includes the death of Kathleen O'Hagan in Greencastle, County Tyrone in August 1994. She was 7 months pregnant. Her baby also died in that attack, and it was claimed by the UVF. And I could continue into all of those 60 cases. When people talk about confidence, there are over 160 people who have confidence. I fully recognise that we do not have the confidence of all of the victims and survivors out there. I hope through the politics and the decisions by the courts, we get to a stage when more of those people have confidence to come to the Commission.
Thank you.
Can I just, for the record, indicate one of those cases, the Sefton case, Peter said that they'd been shot. In fact, it was an undercar booby trap bomb.
Sorry, yes, that's right.
Yeah.
Thank you for that clarification. Just before we move on to other members, just if perhaps, Sir Declan, if you can say in terms of how, on this question of the Commission's engagement strategy with its detractors, can you just say a little bit about what the Commission has been doing to engage with the sceptical parties out there?
I mean, at the start, I was able to engage before actually the legislation came into being. People were prepared to meet me, and we had straightforward discussions. But as the legislation and the litigation started, things became more difficult. So just before the litigation started, there was an event at Queen's University in relation to legacy as a whole, which I asked to attend, and I was very politely asked not to come because it was going to be used as a strategy meeting for various groups. And since then, although I have on occasions, particularly if I met those who were protesting, invited them to come to the Commission to speak to us, there are groups who, at the moment, I think because of litigation, feel that it would be inappropriate to do so. Now, we have engaged very widely with a lot of other groups who have been happy to speak to us. So the veterans community in various regards, both here and in Northern Ireland, we have spoken to. We have spoken to a number of groups, particularly around border areas in Northern Ireland, where a lot of the deaths occurred, and we have sought to engage within the community as well. I did a talk recently to a Methodist grouping in Knocknagoney about the work that we were doing as part of our outreach. And certainly, I think one of the things that I think your committee has been brilliant at is gathering in a wide range of views. And the message for all of us, I think, is that once you've finished your work, that maybe we should all be sitting down together to see what we can agree and what it is that we can't.
Thank you, Sir Declan. Well, on that note, I'll pass over to Claire Hannah.
Thank you. Thank you very much for coming before us, and I accept that we're all trying to move forward and shape a regime or a set of processes that can get people, as you say, the unvarnished truth. And I'm not going to look backwards, but I hope you will acknowledge that referring to critiques as unwarranted criticism, when a number of those criticisms were upheld by the Court of Appeal, and I suppose it didn't help in terms of the tone of the engagement. I'm not necessarily. I'm very happy for you to come back in. I'm not hoping to relitigate.
I'm not necessarily going to take issue with the fact that the litigation has been very difficult all round. I think it's been difficult for families. I think for us, the decision of the Court of Appeal changing the position of the first instance court created a problem for us that we have to acknowledge that at the moment the Court of Appeal has indicated that there are certain types of investigations which we can't complete to an Article 2 standard. So I think there were unwarranted criticisms. I've seen people come into before you to say that we do light touch reviews. What we do is a criminal investigation similar to that carried out by the Met when they're looking at cold cases. And we remain in criminal mode with a view to prosecution until such time as we come to the conclusion that there is no real prospect of a prosecution in this case. That is not a light touch review. And we have indicated that to some people who still, I'm afraid, describe it as a light touch review, and that, from my point of view, it's difficult because I don't want to get into an argy-bargy with people who I think really ought to know better. But holding your tongue sometimes can be a little difficult. I mean, you've also had people come in here to tell you that there might be one Canova person in our among our investigators. There are 30 people from Canova in our investigators. If the person who told you that had actually accepted our invitations to talk to them, they would have been able to tell you that, but they didn't.
I'm hoping to get into some of the I suppose experience that you've gained through this process and others, and how it can be applied going forward. In your submission to us, you do outline a number of reforms that you think could improve ICRIR's effectiveness. Have the government engaged with you effectively, and are there headline changes that you anticipate seeing in any new legislation?
Well, you'll know that I have been spoken loudly about the need for Ireland to be involved in terms of providing information, because we are an information recovery body, and I think the fact that Ireland is now engaged with the UK government in this process, I think, will be very helpful. So in terms of what do I want from the legislation, I want to see that there's space for an Irish commissioner on the commission, because it seems to me that if Ireland's providing the information, they ought to have somebody there who's going to be able to speak up for Ireland's proper national security and other protection interests. I want to see that, where we've got IDPs, an information disclosure protocol, which we've got with the security service and with the PSNI, I want to see an IDP with the relevant authorities in the Republic of Ireland as a way forward. Again, that is not part of legislation, but it shows the commitment that you require if you're going to make this work. Because if we don't get the information from Ireland, there'll always be questions around. And I think the signs of the discussions that are ongoing and the way in which the two governments are now working together suggest that something of that order may well come about.
Colleagues are going to come back on some of the issues around disclosure and around commissioners. Given that the Court of Appeal, though, has found that in its current form some of your investigations aren't Article 2 compliant, particularly around disclosure and next of kin participation, do you accept that in this context, where we currently are and with understandable pressures of time, that Bridie Brown is still well within her rights to pursue a public inquiry into the murder of her husband Sean?
I mean, obviously anybody is within their rights to pursue a public inquiry, particularly if they're advised by their lawyers that that is the right way to go. I can't comment on what the Secretary of State is going to do in relation to that. I mean, that's obviously a matter for him. I could tell you, if you want, what we would do if the Brown case was referred to us. I'm happy to tell you that if you want.
But can you understand that, given that clearly the court, successive courts have said and acknowledged that the current processes are not compliant, that you could retrospectively have challenges from families whose cases have been progressed under the current procedures?
I can understand that, but as I say, if you wanted me to tell you what we would do and how it would be Article 2 compliant, I'd be happy to do that.
The court has found that the processes aren't currently, and the new regime is not in place, and time is not necessarily on this side.
I agree with that. But if the case came to us, we would do what we do in any case. We would carry out a cold case review. We would carry out a scoping exercise. We would treat the case as a criminal investigation and gather all the evidence in relation to that, which would take the time it would take. But I agree that we could not do the next step, which is subsequent to that, once the terms of reference had been set, and up to that point, we're definitely Article 2 compliant. But the next bit is having identified what the issues are, to then organise a hearing with proper representation by lawyers in relation to that, and also understanding that the sensitive information arrangements, in my view, need to be reviewed, and the Commission needs to be able to exercise proper challenge in relation to those. That those two things are probably the subject of amendment to the litigation, which will have to be looked at.
I'm going to come back to disclosure, but I'm aware colleagues want to get in. Thank you.
Thanks, Claire. Pass over to Gavin Robinson.
Thanks very much, Chair, and good morning to you all. Sir Declan, you mentioned at the start in your opening remarks that you had 4 propositions to give to us, and the last one, and to paraphrase in a non-verbatim way, in case I'm pulled up by a former member of the judiciary, a reset moment, and one in which you hope to support 2 governments in where they land. And I think you've fairly also reflected that where we go is a matter for the Secretary of State. How much of an indication can you give our committee around the engagement you have had with the Northern Ireland office on their plans for augmentation, and how confident or comfortable are you with those plans?
I think it's probably better for me to hand that to Louise and Stephen, because they are the 2 who have been directly involved in the discussions.
Thank you very much. And briefly, perhaps Stephen might pick up on some of the detail, but in response to your question, Gavin, I would say we've had ongoing cordial and robust conversations with those officials within NIO who are seeking to examine the policy and ensure that the subsequent legislation accords with that policy. I think a couple of key things in there. One is, and it is to restate what Sir Declan has already said, is that we are fully committed to the issue of reform to strengthen in order to deliver for victims, survivors and families, and that has informed our engagement with the NIO throughout. Perhaps, if I may pass briefly to Stephen, he might give you a flavour of some of the key areas that we've discussed.
Yes, and in my role, I've seen the shortcomings of the current Act, and that's been the subject of our discussions with the Northern Ireland office. The courts have highlighted these, so have we. We've interpreted the Act creatively where we think it's right to do so. And actually later today we're going to publish the template for our information disclosure protocol that Declan was talking about when he mentioned IDPs. So these protocols are evolving frameworks for managing sensitive disclosure with agencies like the Police Service of Northern Ireland and like MI5. Also, enhanced inquisitorial proceedings, known by several people as EIPs, are another example of our creative approach. We want a human rights compliant version of EIPs put into law. And today we're also publishing a summary update of our framework for promotion of reconciliation. The Act's abstract legal objective is now a procedural, organisational duty. So we're led by law and we're ready for reform. And we're eager to assist Parliament in shaping new legislation. And in our submission, we mentioned a number of areas for reform, and these include greater independent oversight, a voice, statutory voice for victims and survivors, statutory investigations, not reviews, light touch or otherwise, a statutory conflict of interest policy, a self-initiation power where there's a thematic link between different events, and indeed a power for Chief Constables to refer cases directly to us when new evidence comes to light. So there is a lot for us to discuss, there's a lot for us to think about. As I say, we're ready for reform and we welcome it.
Have you found any resistance to those propositions from the Northern Ireland office?
We are continuing to discuss all those issues with them, and I think probably it's best for me to say it's for government to respond.
Well, we will hear from government in time, but this is your opportunity to let us know if there are areas for which you feel the process could benefit greatly from, but there is reticence or reluctance on the part of the Northern Ireland office.
No, we think the Act can benefit from improvement in all of those areas. We're an independent body, and we've put all those points to the Northern Ireland office, and we're having very positive, constructive discussions.
In terms of referral, you mentioned the PSNI and the suggestion that they should be able to refer into ICRIR. You're aware that there's suggestions other organisations should similarly be empowered to do so, like the Ombudsman's Office, for example. I assume there'd be no reticence around the expansion of that list.
I think we're open to all constructive suggestions that are made from whichever quarter, whether they're made to us or made directly to the executive.
I just want to ask about Stormont House, and we hear about Stormont House quite often. Very rarely you'll find people will say no political party supported the Legacy Act, but very rarely will you hear that that was for different reasons. So too, you will find people say that there was unanimity around Stormont House, and there clearly was not. One of the elements around Stormont House that is frequently referred to, and it's separate from ICRIR, is that Stormont House had a firewall between information retrieval and investigations. Is that something that you feel is a vulnerability within your process that needs to be amended?
I don't think so. Well, I don't think it's a vulnerability. We've looked at whether, if victims want to meet perpetrators or representatives of perpetrators, whether there should be a mechanism for them to do so. So the first thing about anything that, as it were, goes beyond the report that we produce is that it must be victim-led. It's not for the perpetrator to make any decision about this. It must be victim-led. Second thing that, and we had our external assurance group reflect on how this might be done and what the mechanisms might be. And the advice back to us is that it's certainly worth thinking about something after the report has been prepared, where there might be a way of enabling some kind of meeting between the victim and the perpetrator. But the advice is that you need to be astonishingly careful about this, because the danger is that you will actually re-traumatise the victim in this. I think if it is going to be contemplated, I would have thought the most sensible thing to do is to think carefully about it and then to run something as a pilot, rather than just to put it into the legislation wholesale. But I can't overemphasise the advice to us from the external assurance group, which included some experienced people in this territory, that you do need to be very careful.
Another, Peter wants to come in, but there are two things that arise from that. The first is, did your external assurance group indicate what impact a separation of these functions would have on timeliness, on process, on timeline, on the effective delivery of answers one way or t'other for families? And secondly, and perhaps more fundamentally, you have the presence of an external assurance group, yet we've heard ad nauseum that the one thing you lack is external oversight a la Canova. Yeah. One thing you could benefit from is external oversight a la Canova, but you have an external assurance group. So could you maybe address the fundamental dichotomy about people suggesting that you have something that you have in all but name?
We put the external assurance group in place ourselves because we understand and recognise that external assurance for an organisation of this sort is absolutely critical. So if, as I think is possibly the intention, there is oversight at a statutory level which is going to replace the external assurance group, we are more than happy for that. But we felt that we needed an external assurance group to do this. In terms of your question about finality, I mean that is one of the difficulties about going down the route of having something beyond the report which would be prepared as a result of the investigation and that we're carrying out. But the other side of it is, I said at the start that whatever we did, it had to be victim-led. And if victims come to us and that's what they want to do, and we could put in place something that might assist in relation to it, then I think we have an obligation to think carefully about it. And Peter has some direct experience about this, which he can maybe recount.
And I'll come to that. Second, just to answer that question about the separation. And of course there are advantages and disadvantages to all of these things, but if the victim is put first in their choice, then that's important in it. But let's take, for example, there's a separation. I'm carrying out the criminal investigations, which will have to happen first. And I present the evidence to Sir Declan and his team, and they write a findings report to say this is what happened. Then the requesting family member goes to the information recovery side. And let's say some people who are former in paramilitary organisations come and give information to that. What happens if, first of all, how's that verified? I mean, under the bodies for the disappeared, it's easily to verify because the body's recovered, if that information is correct or not. But how is that information verified? Who verifies it? And what if it's different from the report we've just written? Does that mean that my investigation is no longer Article 2 compliant because it didn't take account of this information into it? But I understand the importance of it because when I was Chief Executive of Cooperation Ireland, there was a widow who came to me. I didn't know her. She wanted to meet the perpetrator of her husband's murder. I didn't know him either. But through a process, I got the two of them together and I went into the room with them. I said to them, look, I feel this is a private conversation. And the widow said to me, no, I want you to stay. I have never broke the confidence of what was said in that room between them, except two things struck me about it. One was how respectful the conversation was, even though this person had been involved in the murder of her husband. But secondly, the questions this lady was asking, she wasn't asking what I would have thought as an investigator. She was asking the simple things. Were you following our kids to school at the weekend? Did you follow them to the swimming pool? Were you looking through our windows at night time? And these were things that were with her for over 40 years, and she rhymed them off. It wasn't just that this was somehow today she thought about them, this has been in her mind. And he answered them and answered them honestly and then told his own story in it. And, I left with the two of them embracing in it. And that was one sense of reconciliation for those people. Now, not every victim wants to meet the perpetrator in it. But I do see that there are other opportunities. And it's one of the reasons I put my hand up to apply for the commission, because I could see that there are other possibilities in it.
Thank you. I will come back later on issues around Irish government involvement and on autonomy. But thanks, Chair.
Thanks, Cameron. Katrina Murray.
Yep. Thank you. Thank you all for coming today, and it's been very interesting to hear your responses so far. And one of the things, particularly picking up on your point, Stephen, about creatively a creative interpretation of the law. However, there is some things that you cannot be creative about, and the fact that the law is the bit that in the Legacy Act. The Legacy Act, which created ICRIR, has been found, as particularly around the concept of conditional immunity for people coming to it with information. That's the bit that's been deemed to be incompatible with ICRIR. Is not a criticism of any of the individuals in role. It is the act in itself. How do you envisage truth recovery, particularly from non-state actors, being able to be pursued in this regard? Now that conditional immunity is effectively off the table.
Well, obviously we have a wide range of information gathering powers. Certainly from government, from law enforcement, from the military, from the intelligence agencies, we have extraordinarily wide and, on the face of the statute, unlimited powers to gather information from them, which can be useful when we're engaging with non-state actors. Obviously, we have a separate power to actually compel answers from individuals or indeed companies or unincorporated associations without fear of self-incrimination, and we can use that power at the right time in the appropriate case. And in addition to all of that, we have officers who are designated with all the powers and privileges of a constable. And indeed, we want to ensure that in exercising those powers in a criminal investigation, we have exactly the same powers as a police officer would have. So in all of those respects, we can obtain information from non-state actors in using our powers under the Act as it is.
Are you getting people coming forward? Oh, sorry.
Could I put a supplementary onto that? I mean, it's important to recognise what we're talking about when we're talking about people who want information. These people have had virtually no information about their loved ones at all. They haven't been told anything about the police investigation. They haven't really been told anything around what was in the inquest. There has been, the way in which they have been treated in modern standards is shocking, because they're people who all they know is the bare events of what happened, but they don't know anything about the rest. So for them, the information that we are able to provide is astonishingly new and informative and helpful to them. The other thing in terms of perpetrators that I think it's important to point out is that there were quite a number of people who were convicted of serious offences in relation to what happened in the Troubles, and certainly for those people there's no issue about criminality in terms of them answering questions, and no reason why we shouldn't pursue them to seek to obtain answers.
There are two things that always come back to me on this, particularly when we're talking about truth. Prior to my election here, I was a trade union representative, and there was always going to be one more version of the truth than there were the number of people that were involved in the matter. And particularly when we're trying to get to a truth finding and an establishment of what would be, particularly if you're saying that we're beyond, if you're continuing a criminal investigation, it is basically on the basis of meeting the threshold of beyond reasonable doubt, or then this is probably balanced. This is pretty much we can gear the information we found out if it's not meeting those, it's not able to meet those thresholds. I might be wrong, in that. So, but it is then dependent on particularly those range of paramilitary organisations which Peter referred to earlier on in the caseload that you're already maintaining, to actually come forward and say, if we're going to get resolution for these victims, they need to be able to understand what's been going on from those paramilitary organisations. How do you get that information forward to them in a way that gets that through?
I mean, I don't think you were there at the time, but I spoke to the Northern Ireland Affairs Committee way back in the day when the legislation was working its way through about the conditional immunity provisions. In my view, the conditional immunity provisions were a facade which actually hid what was in practice going to happen. The immunity provisions, in my view, were only likely to be used by people who were brought in for interview with their solicitor beside them, and as a result of the interview, the solicitor told them, look, I think you're going to get prosecuted here and you'll go down, and that in those circumstances you might be best just to tell the truth and get off. But if you were interviewed and the solicitor came out and said, well, they've got nothing, don't worry about it, nothing would have been said. So I don't think the immunity provisions were actually going to provide any meaningful information anyway, because we haven't seen from the paramilitaries anything to indicate that they recognise their responsibilities. And of course, if the paramilitaries do indicate that they want to participate in this arrangement, then I think that would be another plus for everybody.
Of course, there are other means of getting to the truth than simply interviewing people and asking them to tell you the truth. There are provisions in the Act about biometric material, ensuring that DNA evidence and profiles are not destroyed where they otherwise would be. So there are other means of getting to the truth that I wouldn't want the committee to overlook.
And probably moving on to one other point, is that given the challenges that you've had within your time of operation so far, being able to get trust and engagement with ICRIR, is it tenable to retain the 5-year limit for people to request the Commission to undertake investigation?
Well, if I may respond on that, I think that Declan said at the beginning that this is a reset moment. Mm-hmm. So undoubtedly, if we are to fully serve victim survivors and families, actually in ramping up into a new regime, and governance is going to be really at the heart of that, oversight, the scrutiny, giving people confidence. No doubt government will give very fulsome consideration to whether indeed it will in the next bill extend that, and I go back to, why are we here? We are here to serve families and victims who have been poorly served in the past.
Thank you.
Thanks, Katrina. Dr. Alpingert.
Thank you very much, and excuse my momentary absence from the room. I hope this hasn't been covered while I was away. One of the things that we obviously know from the Secretary of State is that he's said that he will legislate to ensure that certain inquests involving particularly sensitive information and unable to conclude through the coronial system would be processed through the ICRIR. Maybe starting with you, Declan, can I just ask you, why in your opinion do you feel that's necessary?
Why is it necessary?
Yeah.
I can't. I suppose I can't speak for the Secretary of State, who obviously does consider it necessary. I can certainly talk about some elements of this. I mean, one of the things that I think, whatever we do, that we have to have at the end, is that for victims and survivors, if they have, whether they have a public inquiry or an inquest or come to the Commission, we must ensure that there is no hierarchy of victims. In other words, that the truth they get from the process is of the same standing. In other words, that it is the unvarnished truth, and that whatever we use, we've got to the bottom line, and that you don't get a better outcome by going to one or the other. I think it's important that all of us who are engaged in any of these arrangements have to ensure that the outcome is what it says in the tin, that it is the unvarnished truth. So, just taking your question again. Let me look at what the, if I can, at what would happen with the EIPs, as it were, if they came to us. I did some of this when I was talking to Ms. Hannah about what would happen in the Brown case. But in every case that we get in, we spend a short time with the case support team making to ensure that people understand what they're letting themselves in for, because this can be traumatic for the people involved. And the next step is to appoint a senior investigating officer in the case so that the investigation can begin. And the investigation will involve the calling in of information using our powers under Section 5 in relation to public authorities, and if necessary Section 14 powers in relation to private individuals to produce documentation. Bringing that documentation in, conducting an analysis of the documentation, maybe supplementing it in some cases with some further inquiries, and leading then to the terms of reference for going forward. And those terms of reference will be looking at whether this is something to be taken forward as a criminal case, or whether there are clear indications that a criminal case is not going to be a runner, and that therefore it should be taken forward as a case where we would be using not criminal powers but commission powers in order to move forward. And during that process, we have to involve the families as we go along. So we, every perhaps 2 to 3 months, we would have a meeting with the family, with the investigators, to ensure that they understand where things have got to. If you're going to an EIP, it's because you are not going to a criminal trial. So what would happen at that stage, particularly if there are new governance arrangements where you have maybe a non-executive chair who wouldn't necessarily be a judge as the head of the commission, and you would have one or a group of judges at the tail end of the commission who would actually be responsible for producing the report. So what would happen at that stage is that the terms of reference would allow you to identify the matters and issue that needed to be addressed, and then the findings team and the judge could then draw up an analysis of what they needed to investigate, and that is likely to be significantly less than some of the material that needs to be investigated in an inquest, because they have to go through a lot of procedural stuff, which in this way would not be necessary. So there would be a hearing. There would thereafter be a draft report. Anybody criticised would have an opportunity to make representations about that. Any family member would have an opportunity to look at a draft of the report and to make suggestions in relation to it, but ultimately whoever the appointed judge was would take responsibility for producing the outcome. And then when we come to the outcome, instead of necessarily just doing it as a court handing down, we have offered a range of ways in which people might want to do it. Some people might want to do it privately. Some people might want to do a court-type hearing. Some people might want to have a press conference. Some people might want to have it streamed. You know, we need to be flexible about the way in which that happens, but the report will be public and will be in the public domain and available to people. So that's a sort of short, possibly too long.
Well, no, not at all. But and it's incredibly helpful. But can I just offer you a counterpoint that we've heard in this committee? So we've heard evidence from various people criticising that particular proposal, using language like pseudo-inquest, saying that this is no court, there'll be no independent judge, families don't have access to their own lawyers, they don't have the same rights of disclosure, and that the executive branch of the government can always rewrite the judgment. What would your response be?
My response is that some of the people who were making those points to you are people who have declined to talk to us, and some of them are people who don't understand our processes, because I've heard people talking to you about light touch reviews. That is nothing like a light touch review. It is a serious criminal investigation carried out by experienced police officers. As I've said, 30 of them from Canova, a range of others with extensive investigative experience in both the PSNI, some in the RUC, some in other organisations as well. So, to talk about, and I think the other thing to bear in mind is this: we had to work out how we were going to do what we want to do within the financial envelope that we have for doing things. Now, I don't know how much an inquest costs, but I know when I was doing the legacy inquest unit, we made an estimate of what we expected the expenditure to be. And at that stage, our working assumption was, on average, an inquest would cost us in the unit £1 million. And in addition to that, you probably would have another £500,000 in relation to legal aid costs and other associated costs. So we were operating on that basis at about £1.5 million per inquest. I talked to you about what we intend to do. We're looking at somewhere between 400 as a very minimum and 800 investigations. I mean, if you were to do those by way of an inquest, you'd need somewhere between 600 and 1.2 billion in order to do them. So we have to think about how do you do this differently. And the way in which we have approached this is, instead of investing our money in a court-based system primarily, we have invested our money in an investigator-based system. And that makes a huge difference to the cost, but it doesn't actually undermine the ability to get at the unvarnished truth. That has been the key to making this work. And unless you have a mechanism like that, which can deliver within the financial envelope that's available, then you're not going to be able to do it. And that was the task for us. That was the big thing that we had to sit down and work out. But what we do is different. And I suppose if I was a lawyer, I mightn't be that keen on it, because it is going to make a difference to the extent to which lawyers will have a role. But they will have a role in cases like the EIP cases, where the investigation itself doesn't actually produce in a sufficiently convincing way the unvarnished truth.
That's a really helpful point about the financial envelope and the need to work within it. Just maybe on that last point that I put to you, though, which goes beyond financial. So this fear, this concern that the executive branch of government can rewrite judgments.
Well, I mean, first of all, there's no way that any independent judge is going to allow that to happen. I mean, that's the point about being an independent judge, is that you talk truth to power, and sometimes, I mean, I don't want to use rude language, but you have to tell them to go away. I mean, I don't want to say what was in my mind at the time. But that's where I think all of us will be in a better position to be clear about this once the Supreme Court deals with the sensitive information point. Because I think we need to know what the law is, and then we need to think about applying it. But for myself, I'm aware from discussions we've had with Michael O'Flaherty, who is the United Nations Human Rights Commissioner, who was in Belfast recently, and we had a chance to talk to him, as we did when he was in Strasbourg. But he is coming over in September, I think, to take a look in particular at this national security issue. And I think for us, we need to be careful about being prepared to challenge a classification of material that maybe is out of date, and we need to be careful to make sure that we understand what is the national security interest that is at stake here, and is it an interest that properly needs to be protected, and we need to be able to, where government is over protective, we need to be able to challenge that. And that's why we want the power to be able to do that.
That's very helpful. Last one from me, and it's just really a question of benchmarking, just so we understand something of the EIP powers. From what you know, are those EIPs likely to have any greater power or authority than coroners already have, for example?
Well, they will have powers similar to coroners and public inquiries. I mean, one of the things that we need to have a think through is that in public inquiries under the Inquiries Act, a minister can issue a restriction notice which would prevent the publication of information that is considered to be contrary to national security. One of the things we need to find out from the Supreme Court is, when you're looking at Article 2, and where Article 2 is concerned with explaining to people what has happened, whether the balance in relation to things like restriction notices needs to change. And I think that's it's a very, very interesting point. Unfortunately, given my present involvement, I'll not be allowed to sit in the case that's dealing with it. But I think it's a very interesting point, and if it's properly argued, I think it will make for a very interesting judgment.
Anna.
Thank you very much. I wanted to come back to disclosure, and the Court of Appeal said in September the Court itself cannot permit disclosure of any sensitive material where the Secretary of State's permission has been withheld. Overall, it says this regime offends against the proper aim of the ICRIR as an organisation able to conduct their work free of state interference. Do you agree with that analysis, and what do you think would be a better disclosure regime going forward?
The answer is, Claire, I don't know, and the reason I don't know is that I haven't heard what the Supreme Court has to say. This issue is going to be before the Supreme Court. It bears not only on commissions like ourselves, but it will also bear on public inquiries generally, because, as I've said, the Inquiries Act, the 2005 Inquiries Act, does have a provision which enables a minister to issue a restriction notice. Now, I think the point may be, and the other thing to bear in mind is that the Jordan judgment itself says that national security has to be taken into account in all aspects of this. But I think the question is whether or not and how the Commission and or whoever the decision maker is has a means to challenge and expose any overprotective restriction on disclosure.
Do we not have good working examples of people taking that balance into account? Would you agree with what the Chief Constable suggested to us, that it should be the judiciary that weighs that balance of national security versus disclosure, or a regime whereby the duty is on the legacy bodies to disclose unless there is a risk to life or to current lawful operational practices?
I mean, I'm quite happy if the Supreme Court says that that's the way forward to do that. I mean, I am also aware, of course, of some Supreme Court decisions in the Shamina Begum case, for instance, which makes the point that national security is both is a legal and a political matter, and whether the courts are in a position to deal with the political element of it is the question. Now, it's difficult for me to answer the question in circumstances where the very issue is itself going to be the subject of debate from the Supreme Court. And as you know, no matter whether it's John Boucher or myself, we'll all have to do whatever the Supreme Court tells us that we have to do.
You haven't given advice, or you haven't engaged with the Secretary of State on the NIO on what you think it should look like?
I haven't got, I mean, until I see the colour of the Supreme Court's money, as it were, I don't think I'm in a position to give any advice to anybody about what the outcome would be. But I am able to look at the present arrangements in relation to sensitive information and say that they are overly protective and clunky, and that they definitely need to change. And Stephen could talk to you more about that if you wanted.
Could I just ask, I suppose, in your experience so far, do you have a sense that security services are interested in engaging with you completely and transparently?
Certainly the experience of disclosure from the security service after we had put the IDP together has so far been good.
So you've engaged with the security services so far, and you found that to be positive?
What's happened with the security service, we have agreed, and John has signed off the IDP for PSNI. So we're now working through some clunky bits of that within a standard operating procedure and SOP. That will not be a problem. The security service have said to us, we see the IDP, we're not taking issue with it at the moment, let's work it for the next 6 to 12 months and see how it goes. But it's exactly the same IDP as we have with John and the PSNI. And so far, in a sense, the security service is doing what the IDP wants. John has told us that he's not going to do anything because of OMA, but he has given us the keys of the kingdom, and that he's allowed us to go in and use computers within PSNI in order to retrieve the information, and that's where there's a bit of clunkiness, because some people haven't got the message that's what we're able to do no matter how secret the information is, and we might have to ask John to wave his wand and make sure that all of that goes away, but I have no concerns that it's going to create a problem.
Different characterised, I suppose, in different ways, other bodies and others in terms of their engagement on some of those matters, but I will leave it there because I know...
Well, the only other thing I'm going to say is, 20 years ago, Nuala alone didn't get the information that the coroner got in Sean Brown.
Absolutely not.
The question is, does that indicate a change in the approach of the security service? That 20 years ago they didn't provide the information and today they did. I mean, I don't know. But
we can give examples that are a lot more recent than 20 years ago of relevant material.
Canova is an example in that there was information that didn't get to Canova, and there was an inquiry in relation to that. So I don't think, I'm not naive enough to think that you just stand back and say, well, undoubtedly the security service will give us everything we have. We need to look very closely to make sure, whether it's the security service or indeed the PSNI or the MOD or anybody else, we will need to look very closely to make sure that, having looked at it, whether we should be challenging the extent of information provided.
We had witnesses in the very recent past, including from Canova, that gave a different, I suppose, encounter in a different character to their engagement on disclosure and the information that they were able to access.
Well, John has had a major issue on disclosure.
And not just John, Canova's current leadership as well.
But there has been a major issue on disclosure, and that's around the issue that is before the Supreme Court, is about what constitutes national security, who makes the decision in relation to whether or not it's dealt with. If the courts are to deal with it, how do they deal with the political aspect of national security? Those are the questions that the Supreme Court is going to have to address.
I suppose I would just say that the political analysis of the security services there's no record of that being conducive to truth and reconciliation in our region. Their political analysis should not be elevated and above the needs and the lawful rights of those families to information.
Yeah, I as I've said, it's up to the Supreme Court. It's not up to me.
Evan Robinson.
Thank you very much, Chair. And I think that exchange gives a reflection that, irrespective of the legal outcome of the Supreme Court's adjudication, the impact on a failure to disclose is fundamental to confidence in the process and allows people to suggest conspiracies and suggest cover-up even though they do not exist.
They do exist, though.
Well, I'm saying there are circumstances.
I agree with that.
There are circumstances where it may be entirely legitimate to withhold information, but it's going to have an impact on confidence and whether people believe there are conspiracies. That's not a catch-all, but that is a potential. And so my question, I suppose, was, is there a way in which, because we can't control what the Supreme Court decide, is there a way in which experience can be taken from the special advocate process that we're aware of that would instill confidence in families, even where there has been a refusal to disclose information that they would otherwise wish to see?
The question is, if you want to put it another way, if there was a special advocate, possibly one chosen by the families, who was in the room and agreed that the information couldn't be disclosed, would that increase confidence? I suspect in some cases it might, but I know in other cases it definitely wouldn't, because no matter what was said, the fact that people didn't get it is going to undermine confidence. But it leads into, I think, another proposition. And I mean, to some extent, it depends whether this becomes an endemic problem or whether it becomes something that is highly unusual. In other words, that the onus will be on all of us in order to make this work. And it seems to me that the Secretary of State should be trying to make it work, the Security Service should be trying to make it work, and everybody else. But the onus will be on all of us to find forms of words to ensure that where there are these types of issues emerging, that we are able to provide families with a sufficient indication of what happened to ensure that they are satisfied that they've had the unvarnished truth about what happened to their loved one. And if we can do that in a very high number of cases, the fact that there might be the very odd outlier in which you do have the backup of possibly a special advocate agreeing that the material couldn't be disclosed, that the effect on public confidence might not be so great. But if the proposition is that there are going to be lots of cases involving security service material where essentially the 7 blank sheets of paper are all people are going to see, it's not going to work.
I'm going to move on now to another series of questions, but I think I want to start it this way. You're Chief Commissioner. As Chief Commissioner, are you independent?
I certainly feel independent, but in terms of the governance arrangements for the Commission, I think it is quite extraordinary that the governance arrangements would limit the pool of people from whom the Chair, the Chief Commissioner, could be selected by making it somebody who's held high judicial office. In most organisations that have a Chair will look around for somebody with experience of being a Chair rather than somebody who's experience of sitting in a chair.
But the purpose of you being there as a senior judicial figure is by very definition the independence that comes with that role.
Well, I think that you can actually enhance that independence if you have a non-executive chair who doesn't have to be a judge, and maybe somebody of some standing, you would hope, and then you put at the end of the process an independent judicial cohort, so that they are not part of the Commission. They are almost like people that you bring in to do a public inquiry, and you leave them to be the independent end. And I think actually that system improves the governance arrangements at the top by having a sensible arrangement for the selection of the chair, and it improves the independence at the far end where the judges are independent and therefore are able, no matter what the Commission says, are able to say, well, this isn't good enough.
Sure. So that's oversight and that's independence, but I suppose the purpose of the initial question is to determine that as Chief Commissioner, you're not there representing anybody.
No.
So I was surprised to hear you mention earlier in the session that you believe that there should be a Commissioner for Ireland, and you went on to say somebody who can speak up for Ireland's interests and their national security. Is that not a bit curious?
No, I don't think so, at least. I think that the Commissioner is the way to do it, but just as there needs to be some mechanism for looking after the national security interests of the United Kingdom, there needs to be a mechanism if Ireland is going to provide information.
Just be clear, there's no Commissioner representing the security services.
No, there
isn't.
There's
no Commissioner representing the national security interests of the Irish Republic.
Yeah, but you do at the moment have a Secretary of State who can exercise a veto over the disclosure of information.
It's a separate point, and that's why I want to focus on this, because it seems curious to me that a Commissioner would form that role, of one of numerous Commissioners would form that role as a Commissioner.
I'm relaxed about the title that the person would have, but my point is that there needs to be some mechanism within the Commission for ensuring that the disclosure of material where it affects Ireland's national security interests is balanced in exactly the same way as there is a mechanism for disclosure of UK national security interests. Now, if you want to do that by having the Irish relevant minister in Dublin making that decision, that's fine, but I would prefer that there was somebody within the Commission from Ireland who was there, so that the Commission would have the opportunity to engage with that person, whether it is through being a Commissioner or by being some other separate representative. But there needs to be somebody there to make this work, because otherwise I would be worried that information will not be forthcoming.
Just worried about the sort of the contamination of Commissioners.
Right. I take
I
the
invite
point.
you even to reflect on the comments and to perhaps present it in a way that you need a Commissioner who understands Ireland, Republic of Ireland state institutions in the same way that in the Supreme Court we have judges that understand the legal complexities of our jurisdiction, but they're not there to represent Northern Ireland's interests in the Supreme Court.
Oh, but you do need, Gavin, to have somebody somewhere who is, because you can't just say to Ireland, well, you haven't got a national security interest in the same way as the UK has. They both have national security interests, and we have to find within the Commission a way of ensuring that those national security interests
I disagree with that clarification.
And therefore, I'm perfectly happy to take your point is that in that any commissioner who happens to come from Ireland who's to bring context is fine, but that the mechanism for ensuring the national security interest would have to lie somewhere else.
Thank you. More substantively then, the Stormont House Agreement envisaged an information retrieval body that would operate cross-jurisdictionally. How much preparatory work has been engaged with to expand ICRIR in a way that would incorporate Republic of Ireland jurisdictional issues, national security issues? Do you feel that that will form a substantive part of this reset moment that was referred to earlier?
I've been publicly open about this. I think it is essential that this forms part of the reset moment, because it is essential that all of those people who for so long have wondered about what information Ireland holds in relation to what happened to their loved ones need, under this reset, to find out the answer to that question.
Do you have any concerns about how that would work, or are the mechanics of that being explored at the moment in detail, or is it still just an aspiration on your part?
I don't think it's just an aspiration. I mean, the two governments have been engaging in all sorts of things, and I'm confident that they're alert to the issue. I mean, I have tried to make it as public as I can, but I'm confident that they are alert to the issue, and that I'm still, of a view that I could see a day when there's an IDP with the relevant authorities in the Republic of Ireland.
And Gavin,
that's where we want to go.
Just so you're aware that we have been approached by people from the Republic of Ireland where deaths occurred in the Republic of Ireland. Even though I have no jurisdiction, but under the Act I can still take those cases on. So there are people who have approached us.
I'm not pushing back against the notion. I think I'm trying to get a sense of how far advanced these discussions are and what's left to do. And just finally on this section, because the chair is always curious to keep me going, the Stormont Committee that you appeared before, Sir Declan, you mentioned the need for Irish commissioners and international commissioners. And given the exchanges we've just had, is there a danger that the Commission and commissioners almost morph into what you would expect of an external oversight body, with international reflections and potentially Irish reflections? Do you need an international commissioner, or do you need international expertise on an oversight body like your external assurance body you already have?
Well, we have an international commissioner on our present body, Rogelio Alenzo, from Spain, and the Act, of course, required us to have somebody with international experience. I mean, the reason for that is, it's somebody who's able to raise the question when you're looking at different folks, how different folks have actually managed to address some of these issues. And Rogelio has been very helpful in terms of providing us with thoughts about different places that we hadn't thought of going to look for solutions. So I think the value of having somebody with an international perspective on the Commission is something that we should be looking to replicate. I think if you're going to do that, I'm not so sure that the present quotient of 7 commissioners is enough. I think you need a bit more.
Yes, just on the international aspect of this, and it sounds as if both governments are going to agree a body that is going and capable of operating cross-jurisdictionally, it's going to have an international feel to treaty type organisation. Are there discussions actively ongoing? Perhaps it's Ms. Hunter, Wade Hunter, could answer this, around budgetary contributions from the Republic of Ireland government?
I don't think that I could speak confidently to that point, Gavin. I think my focus in terms of of funding and my engagement with NIO has largely been around the issue within the very challenging fiscal environment we have and the spending review. But I don't doubt that it may indeed be on the table at some point at those levels.
Thank you, Gavin. Lee Ingham.
Thank you very much for giving evidence today. Your answers have been really helpful. One of the things the committee has heard numerous times actually is that Operation Canova is seen as the exemplar model for this kind of work. Stakeholders we've met, including the Wave Trauma Centre, said that the ICRIR structures and family support services do not compare with Canova. So I wanted to get firstly what your response was to that comment, but also John Boucher has been lauded, former head of Canova, has been lauded for his approach. The comments we received were that he spoke to every single person who was involved in his investigations. He instilled confidence and trust, which wasn't there at the beginning, so it was a journey that he went on. But he told them stuff, he told them what he was doing, and he told them in advance about what he was doing. Do you think that ICRIR has the leaders, structures and powers in place to replicate this model? And also, what other elements of Canova are ICRIR considering adopting or lobbying the government to legislate for?
I suppose the first point...
There's three questions, yeah, sorry, that was a lot, wasn't it?
The first point I'd make is, the criticisms that you've heard made of ICRIR are not coming from the people who've come to ICRIR. Those people have been welcoming of what we've been doing. We've included in our paper some of the comments that we're receiving. These people look upon us as a chance for something that they didn't think they were going to have for a long time, and it's very important that in assuming that the victims were critical, victims are critical of what we're doing, that in many cases those victims are not aware of what we do or how we do it, and we know that because of the number of people who come into you to say, for instance, we do light touch reviews. They have not looked at what we do. They do not understand what we do. And I mean, I don't want to hog the answers to this, so I'll hand over to others.
Maybe I just pick up, Lee, because let me read to you a comment that somebody recently sent in to me. This is from one of the requesting individuals. Just a few quick words to essentially say thank you. I'm aware this project is a plane being built whilst taking off, and both of you have been amazing. Myself and, to name somebody else, appreciate the meetings with the updates, your prompt responses to any queries we have, and how considerate you have been in dealing with both this situation and our emotional responses. Keep up the good work. I get that constantly from the over 160 people who have come into us. John Boucher's deputy was Keith Sortes, who did the day-to-day investigation. Keith is my deputy, so he doesn't change his spots overnight and somehow do it differently. He is doing the same as he did in Canova. Canova was different. It was very bespoke. It was about state individual working for the state, and it was right. Our operation is very much different in that I have people from all walks of life, from veterans' families, police officers' families, from the wider nationalist community, from the wider unionist community, and from paramilitary organisations' families who've come to us. So we're very much broader than Canova ever was. And it's why I understand that no police officer sat on Canova. But it's very different for us in the expanse of the work in it. So it's different in that way, but maybe Louise wants to...
Well, I mean, I think, and forgive me, I don't wish to presume that in your question you're suggesting any deficit in the existing leadership. But I
think I'm just repeating what evidence we've been given. That's what we're doing here, is just saying what's been said.
I suppose if I were to talk about the issue, about the backgrounds of my colleagues around me and the long and distinguished public service that they have given, I think some have said have had anxiety around, for example, the background, not simply of leaders within the organisation, but around the background of having RUC officers who have served in the RUC as part of that. And of course, we recognise that the people are entitled to have that view, and indeed there are people who may be anxious about, say, if they're bringing cases forward, how that being able to ask for understanding around that, and indeed we also recognise that the opposite is true, the converse is true, that there are many people who will be absolutely delighted to know that we have people who come from an RUC background as part of our workforce. It is a small proportion of our workforce, I might add, but nonetheless that it is there because they understand the circumstances and the context for many of our cases. So there's something for me which actually transcends simply the issue of leadership and is much more about the diversity of our workforce, the experience that we have, and vitally by putting a victim-centred approach to our work, which we characterise as our trauma and resiliency informed approach, and by looking at our conflict of interest approach, that we are able to do what we're set up to do, which is to serve anyone who comes to us, regardless of their background, and regardless indeed, I would argue, of their fears, because we can accommodate that within that, and that we are unified as leaders of the organisation in being victim-centred in our approach.
And of course, we're looking to get self-initiation powers as well, so that where there is a thematic link with something we're already looking at, we can go where the evidence takes us. So that's another thing we will have in common with Canova. And I think we've got, I think we were discussing about 30 Canova staff among our numbers, far greater than number of people who were in the RUC.
3 questions, 4 answers.
We'll move on to our next question, I think now. Was it an urgent supplementary? Yeah.
A quick supplement. How many declarations or potential conflicts of interest have been declared? Do you, those that match point 10 of your conflict of interest policy?
But certainly I have declared a conflict in relation to the death of Judge Rory Conaghan, because he was my mother's cousin. So I've stepped back from that case in terms of the outcome. I'm certainly aware that one of the assistant commissioners explained to me that somebody had come in to ask about the involvement of RUC officers in their case, and they had done what we expect them to do, to sit down and work through and explain what it is we do, and at the end of that process the person indicated they were perfectly happy to proceed as was. Very few people indeed are coming to us.
I'm talking about investigators and staff, I suppose.
So what happens, Claire, is so as well as when you join the organisation, you do a declaration of it. It's a broader declaration of this. But in every investigation, people have to complete a conflict of interest. So if they have a conflict of interest,
are there? I'm just trying to get a sense of how many are being declared, how broad this is. Because I think you can. Yeah. I'm sure, and I hear and understand your alternative perspective, but I'm sure you can understand the anxiety that people have, and I suppose in terms of creating confidence in a new body that already does have substantial deficiencies. And I'm just trying to understand how many have been declared.
Well, let me give you an example of it, because I think when you talk about the practical, so a case that had came to us, I had signed a search warrant for the after the murder way back in the 90s. Now, there was no way I would ever remember that in it. You know, you just couldn't, given the 30-odd year service, and remember everything that you signed it. But in the examination of it, the investigators came to me and said, I see your name on this. I then complete a declaration of or a conflict of interest and say that on it. So we all...
I was trying to understand how widespread it is, but we've loads of ground to cover.
In the interest of time, we really need to move on, because we have a few questions we need to ask. Gavin Robbins.
Well, thank you, Chair, and I suppose in many ways, Ms Ward Hunter, you've jumped into answering the question that I was going to ask unnecessarily and disappointingly for me, but I think the answers have been clarificatory and helpful. But I have found some of the evidence that we have taken really disgusting on this issue. I've found them hugely prejudicial, personal, not to me, but personal to members of your staff. I have found them politically charged and based on perception from people who should know better, from individuals who would have perceived conflicts of interest in their own roles that they have performed over many years, from police authority to police ombudsman and all the rest, who don't accept there's a conflict, but you could easily make the argument that there was a conflict. And so I suppose I want to give you the opportunity as Chief Executive of ICRIR, because if anyone else wants to contribute, it's entirely a matter for them, but I don't want to personalise this, to ask how difficult it is when you see other professionals that you have to work with on a daily basis on legacy issues, delving into prejudice, delving into perception, rather than challenging it and suggesting that the perception is wrong and that the prejudice is wholly inappropriate.
Thank you for the opportunity to answer that question. I go back to our core ethos, which is we are a values-led organisation. Our core values are impartiality, independence, openness, accountability and respect. And I believe that it is the first and the last particularly which we seek to harness in those sorts of engagements, which is, and for those of us who are veterans of the public service, impartiality in your service is absolutely critical, but as is respect. I recognise that you have characterised some of the criticism, some of the observations. We've already heard from Sir Declan earlier in this session commenting on the factual inaccuracies, while still being very respectful of the fact that people do hold different opinions. I think our mission in terms of building trust and confidence is to seek to factually, where we can, correct, but in a respectful way. And I would go back again to what Declan said earlier on, which is that there is a duty, and it is incumbent upon us to continue to seek to clarify, to continue to seek to engage, and to continue to seek to put the factual position forward as to how we operate, the basis on which we do it, our policies and procedures. Does it sting? Naturally. We're human beings. Is there a much more important focus, victims, survivors and families? Absolutely.
There is a political part to this process. Clearly it's being led by politicians, and Secretary of State will bring forward his process. You have a duty of care to the people that work within ICRIR. Okay. Can I ask you to express whether you have been disappointed or not by almost the silent indifference whenever prejudicial complaints are made on perception of conflict of interest?
I'm sorry, I do beg your pardon. I missed one critical word. Where was I disappointed in the
different silence from other because I think I raise this issue quite regularly, but I rarely hear others challenge the prejudice that is laced through some of the issues raised around conflicts of interest.
I go back to my earlier comments. In terms of we stick firmly to the values of our organisation. We try, and part of our core when I joined, we talked about that our credibility as an organisation would be fundamentally based on two pillars, which is competence, the ability to discharge what we do in an effective way, and the care with which we do it. And that care applies to victims, survivors and families, to witnesses and to stakeholders, but also to our own staff. And so I would say we resolutely keep focusing on what's important, and I bow to those who will advocate more widely in terms of trying to create a more positive environment for us to function in.
When you talked about perception bias, could I just say this, just for the record in this, I have said in other forums that, for example, in the Brown case, if even on the perception that just because I was visible in a different organisation, that the Brown family didn't feel confident, then I would recuse myself in that way, even though it's based just on perception. Now, I do think in the wider context of things, as each of you move on in life, if you're going to be judged for the next job, you look for based on perception rather than merit. I think we get run down a slippery slope.
We are, though.
Well, we're all, and it doesn't matter, Claire, whether you're in the GAA and you're looking for, or you're in a loyal order. If we're going to make decisions on perception bias, then I think it's a dangerous place. Now, having said all that, I completely and utterly understand from some people's perspective that you know, despite the fact I stand on my own integrity on this, I am still willing to step aside if it is important, and it would mean any family could come to us in that way.
And then, thank you, Kevin. In the interest of time, we have the last couple of questions with the hard stops. I'm going to pass over to Chris Blair.
Thank you, Mr. Chairman, and thank you all for your evidence. And it is really useful to hear counter discussion points and arguments, so we really appreciate that. It's really good for members of the committee to hear that and be able to talk back to you about that. So Declan, you gave evidence to the Northern Ireland Assembly Committee in February, and I was really interested in what you talked about memorialising the Troubles and the ICRIR being party to that discussion and playing a role in that. And I was just wondering if you could just expand on that a little bit more for members of the committee.
Part 4 of the Act hasn't been commenced, so those issues have not yet come to fruition. But I think the point that I've tried to make is that when we're looking at reconciliation, we're looking at creating the base from which reconciliation can spring. In other words, you can't have reconciliation until you've gone through the difficult process of having the truth told about what happened to everybody during the Troubles. And you know, a sign of how difficult that is that we were able to deal with our issues over police. We were able to deal with our issues over decommissioning, but we still have not been able to deal with our issues over how we manage that issue. Now, that is just an indication that this is something that in Northern Ireland terms, for a whole host of reasons, is exceptionally difficult. And I think what I envisage is that, you know, memorialisation, I suspect we may have to recognise that how that is done will have a total community element to it, but it also may have an intra-community element to it as well. Some areas which were seriously affected by the Troubles may have a memorialisation of a certain kind. Areas that were, and there were areas that were largely immune from the effects of the Troubles, may approach this in a different way. So that's where I think, you know, there needs to be discussion. There needs to be engagement with the community about that, in the same way as for the historical record. I don't think that we should be sitting looking at repeating lost lives and simply producing a book. I think we've got, you know, we live in a different world, we live in a digital age. Should we not be thinking about it in a completely different way, trying to tell the story of what the Troubles was like, and reaching out then to the public to say, look, you know, let's have a think about something different here, which maybe will be of help to others who are facing these types of issues down the line. But you know, we want to try and be creative and different and provide people with something which reflects the modern age in which we live, rather than simply repeating what was done, and done to great effect, it has to be said, many years ago. I have one issue, Mr. Chairman, that I do want to raise before I go. I don't know whether you're going to allow me to raise it.
We're very low on time. I don't know if Chris has any supplementary questions.
My follow-up was more, is that a frustration? I understand your answer, but is that a frustration for you that you're not party to that sort of discussion at the moment, and it's not?
Not if we get the chance to do that, okay. Once they actually commence it.
Thank you.
In which case, I'll move on to our final question, and if it's appropriate to wee you in what you'd like to say, so Declan, you may do, but we do have a hard stop. We've been talking about memorialisation there, and but an associated issue to memorialisation and truth-telling is reconciliation, which is the primary objective of ICRIR. Yet the Commission doesn't have a definition, and we've heard from witnesses that, you know, that's problematic. Should there be a definition? What is it if there is a definition? And if not, should reconciliation be separated out from the purpose and remit of ICRIR?
I think the point is, as I've said, that ICRIR's purpose is to provide the basis for reconciliation. It's not there. In other words, that's how it promotes reconciliation, by creating the ground upon which reconciliation can flourish. But the way in which societal reconciliation may evolve, because I don't think we are talking about personal reconciliation, the way in which societal reconciliation may evolve, in my view, will depend upon the communities within which reconciliation is to take place. So what may happen in the areas of North and West Belfast or East Belfast may be different from what happens in the Glens of Antrim or in some other areas within Northern Ireland, particularly those that were relatively untouched by the Troubles. And I think we have to recognise that that's about listening to people, and we've got to allow them to have their say and to participate. I'm going to make the statement now that and my statement is this: if you're looking at restoration of inquests, and I'm not saying in any way that it shouldn't happen, you must ensure that the funding is there to go with it. Because don't leave us in the situation that we were in 2016, where we set up the inquest plan, and it took 3 years and litigation in order to get the funding. You can't do that to victims. If you're going to restore inquests, you must fund it, and we haven't. Our budget doesn't allow us to do that because we do it in a completely different way, and our money. We couldn't take 60 million out of our money because it would absolutely wreck us.
Well, on that note, Sir Declan, Peter, Louise, Stephen, thank you so much for appearing before us this morning. We appreciate your time. Order.
Thank you very much indeed.